Hello, this is Patrick Cook, candidate for Adapted PE Addendum, Class GED 6056, and today I'm presenting three important special education legal cases. In this video, I'll be presenting three cases from the early 1980s, the Board of Education versus Rowley of 1982, Ronker versus Walter, 1983, and in 1984, the U.S. Supreme Court ruled in the case of Irving Independent School District versus Tatro. All three cases are very important and have implications in special education student rights. The first case is Ronker versus Walters. This is a case involving the least restrictive environment rule, and it was presented in the U.S. Sixth Circuit Court in 1983 and addressed the issue of bringing educational services to the child versus bringing the child to the services. The case was resolved in favor of integrated versus segregated placement and established a principle of portability. The case involved a severely mentally disabled young man who also suffered from seizures, Neil Ronker. Neil was given special education in a segregated environmental setting, which his mother did not want, and she appealed to put him in a least restrictive environment. However, a lower court overturned the school's placement decision and seeking an alternative least restrictive environment. This case established the principle of portability, that if the desired service currently provided in a segregated setting can feasibly be delivered in an integrated setting, it would be inappropriate under the law to provide the service in a segregated environment. The Ronker Court found that placement decisions must be individually made. The ruling also said that school districts that automatically place children in a predetermined type of school solely on the basis of their disability, rather than on the basis of their IEP, violate federal laws. The second ruling is the Board of Education versus Rowley, which is a Second Circuit Court of the U.S., and it found that individualized decisions based on the unique needs of each child were essential under federal law. The case involved a young lady named Amy Rowley. At the time, she was a kindergartner and a deaf student in a school district in Peaksville, New York. The young lady was provided with a sign language interpreter and other services through her kindergarten year and was an excellent student. When she was then given assistive technology in the form of hearing aids, the school district decided that interpreters were no longer needed. Schools who let one criterion, such as a specific disability, automatically determine the placement are likely to be held in violation of federal law. This is a picture of Amy Rowley in 1982. And this case opened the door for many students who were not receiving free, appropriate education as stated in the specific criterion definition. The case required all districts to look closely at their guidelines and procedures for determining the needs of special education students. And this is Amy Rowley in 2012. And currently, she is an assistant professor pretty close to me here in Northern California at Cal State East Bay. She's the coordinator of the American Sign Language program in the Modern Languages and Literature department at Cal State East Bay and does quite a bit of speaking on behalf of her experience with her case in the Supreme Court. This also created the development of the Rowley Standard, a two-part test which determines if a school has met its obligations to provide FAPE under IDEA, and it asks two questions. Has the school complied complied with the procedures of the Act, and is the IEP developed through the Act's procedures reasonably calculated to bring about educational benefit? The critical decision in Rowley versus the Board of Education is appropriate does not always mean optimal. The third and final ruling is the U.S. Supreme Court's ruling in the Irving Independent School District versus Amber Tatro, in which school districts required under the Educational for All Handicapped Children Act of 1975 to provide intermittent catheterization, help students urinate, and that needs to be performed by the school nurse or nurse's aide as a, quote, related services to a disabled student. School districts can no longer refuse to educate a disabled child because they might need such a service. The case involved a young lady, Amber Tatro, who was born with spina bifida. This disease caused Amber various health issues, including a bladder condition that required her to be catheterized every several hours. This procedure was known as clean intermittent catheterization and was relatively simple and could be taught to a layperson in under an hour. This is a brief description of the birth defect known as spina bifida. In 1979, when Amber was age 3, the Irving Independent School District in Texas created a special education program for her, though it did not include the administration of her catheter. Her parents requested that the school provide the service, and the school district refused. The federal district court ultimately ruled in favor of the Tatros, finding that the CIC catheter was not a medical service since a physician did not have to perform the procedure, and instead was a related service. The court further held that the school had violated the Rehabilitation Act of 1973, which enabled it to award attorney fees to the Tatros. The issue at hand in this case is what is the statutory interpretation of an appropriate education. The Supreme Court decision in Tatro's case included general guidelines outlining the scope of a school's responsibility for providing EAHCA related services to students. First, the court reiterated that eligible children must be identified as having disabilities in order to receive special education services. And second, the court acknowledged that school officials are required to supply only those services that are necessary to enable children to benefit from special education, regardless of how easily school nurses or laypersons could provide the needed services. And third, the court noted that school nursing services do not have to be provided if they must be performed by a physician. The Supreme Court of the United States thus upheld the lower court's decision that the school had to provide the CIC catheter to Tatro. However, it also found that the school was not liable under the Rehabilitation Act, and thereby reversing the ruling that the Tatros could now recover attorney fees. This is a picture of Amber Tatro. Thank you very much for your attention. Have a great day.